General Counsel, who has aggressively pursued her agenda of protecting the rights of workers to the fullest extent permitted under the National Labor Relations Act. Passed in 1935 as the heart of FDR's New Deal, the NLRA protects private sector workers who seek to unionize or act concertedly to improve their working conditions, and it also encourages and supports collective bargaining. The National Labor Relations Board is charged with enforcing that statute. Given the broad outlines of the law, there is a lot of room for interpretation. So it really matters who decides these cases, how they decide these cases, and ultimately how they view workers' rights under the law. The NLRB has two separate and distinct components. First, there is the National Labor Relations Board, a quasi-judicial body which consists of 5 members appointed by the president. The board decides cases presented to it, and in doing so, it interprets the National Labor Relations Act, sometimes expansively to protect the rights of workers to organize, and other times, as we saw with, most recently, the Trump board, to subvert the protection of this statute to serve the interests of employers. The other side of the NLRB is the Office of the General Counsel. The General Counsel is independent of the 5-member board and has general supervision over the approximately 30 regional offices which conduct union representation elections and investigate and prosecute unfair labor practices. As the agency's chief prosecutor, the General Counsel decides the types of cases to pursue and the legal theories to advocate to the board. Thus, she is critical in shaping how the NLRA is interpreted and applied to worker struggles. The significance of her position was recognized by President Biden, who minutes after his inauguration fired Trump's anti-union general counsel, and shortly after sent his nomination of Jennifer Abruzzo to the Senate, where she was confirmed in July of 2021. General Counsel Abruzzo made no secret that the cases she looked to pursue were aimed at empowering workers, the goal of the National Labor Relations Act. The moment she walked into office, she hit the ground running. She issued wide-ranging memoranda to all NLRB staff outlining the many types of cases she wanted to present to the board. The depth and breadth of her initiatives have been stunning, from protecting workers who wear Black Lives Matter buttons at work to obtaining stronger remedies for employers who violate the National Labor Relations Act. NLRB attorneys have successfully advocated her theories in cases they litigate and have obtained board decisions that have expanded worker protections. General Counsel Abruzzo not only has sought to overrule the anti-worker, anti-union decisions of the Trump board, which, by the way, reversed decades and decades of legal precedent, she has pushed to expand the rights of workers under the law beyond what Democratic boards in the past half century have done. General Counsel Abruzzo understands what matters to workers engaged in the long and hard struggle to improve their working conditions. She comes from a union family and has represented workers for decades as an attorney at the NLRB, where she quickly rose up the ranks. She left the NLRB during the Trump administration and for 3 years served as special counsel to Communication Workers of America. We are so fortunate to have Jennifer Abruzzo as the NLRB General Counsel and to have her speak to us today. So I now turn this over to General Counsel Abruzzo to describe her view of the agency's mission and the initiatives she has taken to advance that mission. And after her presentation, she will take questions. So I give you General Counsel Jennifer Abruzzo.
Thanks, Ellen, and it's so great to be here. Thank you all for your interest and all you're doing on the ground. I thought I'd just start for a minute. I'm not going to give you the history lesson, and Ellen pretty much spelled it out, but the whole purpose of the act being enacted during the Great Depression was because employees lacked channels of communication to actually engage with their employers to better their work circumstances. And so Congress thought to somewhat level the playing field so that workers could actually engage in collective bargaining and freely associate with one another for mutual aid or protection. So we are an independent, neutral federal agency, but we enforce a pro-worker statute. And that's how I view my role and our mission to ensure that we are promoting workers and empowering workers in every situation that we can. And we are seeing, as you're likely seeing as well, but we are seeing at the board, and you're seeing in the press and the like and on the ground, that underserved communities, underrepresented communities, vulnerable communities, often people of color, are elevating their voices and demanding a seat at the bargaining table. And either through homegrown unions or through established unions or through hybrid unions, frankly, it doesn't really matter. What matters is that workers are feeling empowered to engage with their employers over their issues of mutual concern, whether it's substandard wages and benefits, whether it's health and safety, whether it's inequities in the workplace, lack of opportunities. And Ellen asked me to just speak briefly. I know many of you have union backgrounds as well, or working for unions or on the ground. But, you know, our statute, of course, is workers in this country have the right to self-organize, to join, support, or assist a union, to bargain collectively through representatives of their own free choosing, and to engage together for mutual aid or protection. In other words, to act collectively to improve their wages, benefits, and working conditions, which we often call protected concerted activity. And I'm just going to talk a tiny bit about what we're doing in that space, because I believe that the statute needs to be broadly construed. We need to be broadly construing what protected concerted activity means. In case you don't know, workers in this country, under our statute, they have no private right of action, so they can't go into a court if their rights under our statute have been violated. They can only come to us. So it's really important that we are broadly construing the statute when it comes to who's an employee, when it comes to who's an employer, when it comes to protected concerted activities. And what we're doing at least what I'm doing in the protected concerted activity space is, I'll talk about a couple of things. One is, and this is supported by Supreme Court precedent, the Mushroom and Myers line of cases, an individual, one person, that is initiating, inducing, or preparing for group action and just having discussions with coworkers, whether they agree with that person or not. Just that initial discussion, that initial action, that's the precursor to more solidarity, the precursor to more collective action. And that in and of itself is protected concerted activity, in my opinion. I also think that there's many issues of mutual concern that should be considered inherently concerted. Right now, issues about wages, of course, you know, are the thing that's of most concern to folks, but also scheduling and job security. And there is board law out there that those issues are inherently concerted in and of themselves. But I think we need to expand it out to health and safety. We need to expand it out to racial, gender, and other discrimination. And finally, and Ellen touched upon this, but I also believe that social and economic and racial justice advocacy, that such as the wearing of Black Lives Matter logos, obviously there's a broader societal interest, but there is also an interest for workers to improve what is going on in their own workspaces as well as in other employees' workspaces. And so, again, we are litigating cases around that against Whole Foods, Home Depot. We just won a case yesterday or the day before I think, in a Fred Meyer's supermarket case, so that's Kroger is the parent. On that very issue, the ALJ agreed with me and my theory for the first time. We've been putting it out there, and we finally got an ALJ to agree and move forward on this notion that, you know, social, economic, racial justice advocacy that has some sort of nexus with employees' working conditions is protected concerted activity, and any sort of retaliation in that regard is unlawful. So that's what's happening in the protected concerted activity space. And we are also going after, you know, we are, let me tell you, we are woefully underfunded, under-resourced, understaffed. But we are doing really the best we can, and the field, you know, does the vast majority of the work, and they're trying as hard as they can. I know there are delays in case processing. We are trying to get them more help from headquarters, detailees going into the field to help the field. It's just, we just don't have enough money. Feel free to lobby your appropriators and get them to get us more money, but really, we're doing everything we can, processing as many hundreds of union election petitions, and thousands of unfair labor practice charges. Oftentimes, they're related to the organizing campaign that's going on, and we'll go into district court and seek injunctive relief, like we've done against Amazon and Starbucks, to get them to stop their union busting tactics. We won a nationwide injunction for about half a day before it was rescinded, but we're going to keep trying and keep moving forward. But 10J is one tool that we have in our toolbox that we really are using and trying to use more, and because we just want this bad behavior to stop. And I've even asked regional directors to consider seeking injunctive relief, if appropriate, when there is just threats without any sort of adverse action happening, because oftentimes, because you don't want like threats of deportation. You know, that's a significant thing for immigrant population. Like, that's worse than losing your job, right? Of course. So we're looking at whether or not we should be going into district court more, even on threats. And again, regional directors are doing an excellent job of managing those cases. With regard to remedies, this is something that is really important to me, that we are fully making whole victims of unlawful practices. Fully. Not nickel and diming workers. You know, in the past, there was this thing of, oh, you'll settle for 80 cents on the dollar. No. You know, like, corporations can afford 100%, and workers can't. Workers can barely put food on the table. So we're not nickel and diming workers. We're not taking non-admissions clauses in settlement agreements. If an employer or a union has violated the law, then they violated the law. We have found that they violated the law. But the remedies that we're getting have been fabulous and somewhat creative. So I'll give you a couple of examples, because, you know, you're not only looking at the back pay owed if, let's say, someone's unlawfully discharged, but you're saying, what were the direct or foreseeable consequential harms to that person as a result of the unlawful discharge or suspension or whatever it may be? And so, you know, and of course, did they have to take money out of a 401k if they're fortunate enough to have a 401k, and were they penalized as a result of that because they had to pay the rent? That would be something that would be a consequential harm. We've gotten, in a number of cases, relocation costs if someone lost their job and they had to move to get another job elsewhere. That's a consequential harm. Double rent, you know, they're in one place and now they have to move somewhere else, and, you know, there's that overlap. Retrofitting a car. someone had a company car, they unlawfully lost their job, went to another job, did not have a company car, so the bad actor had to pay for the retrofitting of the car. So all of these, and I could go on and on about the remedies, but you also have to consider not only the remedies for discriminatees, those that have been unlawfully fired or suspended, as I said, but you've got to also look at the chilling effect that unlawful firing had on the rest of the workplace, right? So we're getting settlement agreements like, in addition to notice readings by CEOs and making sure that people understand their rights and know their rights, and using Slack and other social media platforms. However, the employer typically communicates with their employees is we're making them go out and post the notice of employees' rights to that workplace. But in addition, we're making employers post the notice of employee rights. And by the way, just to say, there's no mandatory requirement for employers in this country to post rights under the NLRA so that their workers know what there are. In 1935, the lobbying was such, it obviously worked. We're the only worker protection statute where there's no mandate for employers, unlike OSHA and the FLSA and Title VII and the ADEA and ADA and all. There is no mandate where employers have to post the rights under the NLRA. So it's crucial that in settlement agreements and in board decisions and board orders that we are ensuring that employees understand their rights, particularly in situations where there's been violations and it's chilling them from exercising their rights. So in that regard, we've gotten notice of rights in job applications, in vacancy announcements, in company newsletters, and we've even had companies change their handbooks so that it's in plain language. We've had companies who have reclassified workers who were misclassified as independent contractors as employees. We've had employers. We actually, I believe, another major issue is gender identity discrimination, which I believe is also an inherently concerted issue. And we were going to issue complaint regarding gender identity discrimination, and the employer settled. And as part of the settlement, it was required to allow workers to post their pronouns on their name tags and in their email addresses. So we're doing, and even before the McLaren-McComb case issued, which you may or may not know about, but with regard to overbroad provisions in severance agreements, such as overbroad confidentiality provisions or overbroad non-disparagement provisions, which, you know, obviously chills people from helping former colleagues and also chills them from actually engaging with their current colleagues about issues that they don't want to see again in their new employment. So we are just we made sure in settlements that employers were not only excising those provisions from severance agreements, but also telling those that had signed the settlement agreements that they were no longer in effect and that if there were any breach, they wouldn't be enforced. So we did that even before the board issued, but I was very happy to see the McLaren-McComb decision that ultimately came out that actually said even the proffer of an unlawful severance agreement is in and of itself independently bad. So the other thing that I will get to organizing, just give me a minute here, but a couple of other things that I just wanted to bring up. One is our engagement and our partnerships and our collaboration with other agencies. The Biden administration has done a really good job of promoting a whole of government approach, so the governmental agencies are no longer siloed. And so we had, for years, we've been working with the Department of Labor, Wage and Hour Division, OSHA, and the like. And we've been working with the EEOC, of course. Okay, sorry. And you know, the typical worker protection agencies, we had memorandum of understanding with them, we share information with them, we do outreach with them, we do co-investigations, co-enforcement with them. And don't forget, I mean, we, as the NLRA, the NLRB has no independent investigatory authority. So we can't act on a case unless and until it's brought to us. But other agencies do have independent investigatory authority. So the information sharing is really key, because honestly, oftentimes when we see violations of, when a charge is brought and we investigate, we not only see violations under the NLRA, but we see violations under other worker protection statutes. So for example, a group of workers complaining that they didn't get overtime, and they're fired as a result, and said, well, if you don't like it here, go work somewhere else. Well, that's a violation under our statute. They engaged in protected concerted activity to get overtime. It's also a violation under the FLSA. So, so that's what's happening with regard to the typical worker protection agencies. We also, I brought up the immigrant population, one of the most vulnerable, one of the most exploited, and we are doing a lot in that space with regard to, we've got an MOU with DHS. ICE will stand down if there is a labor dispute. I'm certifying U visas for those who have who are victims of qualifying crimes. I'm asking DHS to use its prosecutorial discretion for those who are victimized, either specifically or chilled because there's violations going on in that workplace, where they will provide either deferred action, parole in place, EADs to folks. But the one thing is during our investigation, everyone should know, we do not ask nor do we care about the status of any individual. If they're working, they're a statutory employee. And the only time it ever becomes an issue for us is if they're fired and we're trying to bring them back to work and they're undocumented, then we cannot bring them back to work. So there will be times where our orders will be seeking conditional reinstatement. But during the course of an investigation, no one should ever be asking what the status of anyone is, because it really doesn't matter. The Supreme Court has spoken that they're employees regardless of status. And we're also doing a lot in that space with regard to making sure there's safe and dignified and respectful access to our processes for folks. And that means even going elsewhere if they're uncomfortable coming to a federal building for obvious reasons. Translators, of course, and not making any assumptions about them using a name that may be different at work than it is somewhere else. So, I've issued a memo in that regard. But the final piece on partnerships is something that I'm really pleased that we're doing. It's not something that we had done before. And we've developed relationships with the FTC, with the CFPB, with DOJ antitrust. Why? Because their goals are the same as ours. They're just looking at it from a different lens. And I want to make sure we're bringing to them our lens, our worker protection lens, and they also bring their perspectives to us. But it's all about stopping deceptive and unfair practices, right? Like misclassification of workers as something other than employees. And of course, if you're an employee, you have the full panoply of all worker, all the protection under all our statutes. And if you're an independent contractor or labeled something else by your employer, you have none. And frankly, I think misclassification or an employer leading employees to believe that there's something other than employees is an independent violation of the statute, because it's chilling those people from actually exercising the rights that they have because their employer is telling them they don't have the rights because they're not an employee, or if they exercise those rights, they could be retaliated against with impunity because they're not protected under our statute. So I was unsuccessful in the last I wasn't there during the Trump administration, but even before that, I was Deputy General Counsel at the time, and we brought a case seeking an independent, the board to agree with us that there was an independent violation. We were not successful then, but I'm hoping we will be successful now that I'm General Counsel. We will see. But that's just one, that's one where the FTC and DOJ antitrust, and by the way, they filed a brief in a board case in Atlantic Opera, and it was a really compelling brief because it looked and provided their perspective on why it was so important to label people appropriately, because there is a carve-out under antitrust law for employees engaged in union and other collective activity. If you are an employee, no problem. If you are something other than an employee, you are subject to antitrust liability for wage fixing. Or for example, right? So it's really crucial that people are classified appropriately. There's also the use of artificial intelligence and how, that's a black box with privacy interests at stake, anti-discrimination issues, antitrust issues like blackballing, like wage fixing, like no poaching, and certainly labor issues, right? Not only around duty to bargain and to provide information, but also around the chilling of the exercise of Section 7 rights. If the electronic surveillance tools are so intrusive, monitoring keystrokes at all times, at home, at work, voice recognition, facial recognition, GPS tracking, when are people gonna engage together and feel comfortable doing so to address their workplace issues? Same thing with abusive algorithmic management. You have these tools where people are breakneck pace of work because they have to meet some production quotas or efficiency standards. When do they get to go on breaks? Do they get to go on breaks? And do they get to go on breaks together? And when is it that they're going to engage? So it's really important that, and again, we're all looking at AI from our own lens, but it's important that we're talking together and fixing this together. So that's a huge one for me. As I said, the Miss Class 2, and and there's many others where we're kind of partnering there, but I do want to get to organizing. And what I will say, well, I'm going to start with a little anecdote, which is I was watching, and I've said this a couple of times, and so you may have heard this, but and in front of him as well. But so Chris Small, I don't know if you know Chris Smalls, but anyway, the Amazon labor union president now, who was one, along with Derek Palmer and a few others who were like the spark plug getting the JFK 8 Staten Island Amazon warehouse facility organized. So Trevor Noah has him on his show. It's this David versus Goliath thing, and so Trevor Noah asks Chris, what was the biggest challenge you faced during this organizing drive? And I'm waiting for Chris to say, some egregious conduct that Amazon engaged in, the managers or supervisors. He says, the biggest challenge I had, I'm paraphrasing, was convincing my coworkers that they had the right to organize and that they could not be retaliated against for doing so, and that there was an agency that was out there that would protect that right. And I was like, oh, this is horrible, And it's like, this is what you just don't want to hear, right? Because with knowledge comes power. And employers bank on the lack of knowledge of workers and fire them or discipline them or isolate them to get rid of these troublemakers, or they threaten them or intimidate them or coerce them, oftentimes in mandatory captive audience meetings, which I believe is an independent violation of the statute, because you are requiring economically dependent workers to sit, coercively listen to your anti-union rhetoric when they have the right under the statute to refrain. And so I'm also seeking the board to find that just the mandatory captive audience meetings to be unlawful coercion and interference with Section 7 rights, and such that employers will be required to no longer mandate economically dependent employees during work time to come to listen to their anti-union rhetoric. I hope I'm successful. I don't know. We'll see. And along those same lines, I've also asked, as you likely know, and we've got, the cases are teed up, they're all briefed, around the notion of not allowing employers to abuse our processes. If a union comes and has majority support, and an employer has no good faith doubt that in fact that union has majority support, then the employer should respect the employee's choices and recognize that union and then bargain in good faith. And what happens, and we see it all the time now, because under the statute, a union can be designated or selected. There's nothing wrong with voluntary recognition. But what we've seen, and under Joy-Silk, which was the case that allowed for this and actually said, if the employer has no good faith doubt of majority support, they have to voluntarily recognize, because you don't want to abuse the board's processes by requiring a union who enjoys majority support to file a petition with the board, and during the critical period from the time the petition is filed until an election is held, the employer engages in all sorts of unfair labor practice, threats of closure, intimidation, interference, coercion, firing the main union activist, all of this stuff during the critical period. Why? To undermine union support, to undermine the free and fair choice that the employees made. So I don't think we should be countenancing that. And certainly during the Joy-Silk era, which was from 49 to 69, there were bargaining orders that required employers to voluntarily recognize, because there was no good faith doubt of majority support. But in the cases where there was, and employers could show that, yes, the cards are tainted, or all the signatures look the same, or the supervisors helped give them out, or there was somehow whatever the story was, that where there was some good faith doubt of majority support, we saw more clean campaigns by employers. We did not see as many unfair labor practices. And of course, we're all about deterring violations. You don't want people's rights violated, right? So I think it's really important that we go back to the Joy-Silk era, and hopefully the board will agree. As I said, it's been briefed. And along those lines, of course, as many of you know, organizing is just the first step, right? The real key is bargaining in good faith and actually getting a collective bargaining agreement that is going to improve wages and benefits and working conditions for the unit that you represent. And right now, I feel under the board law that, and it's a case called Excello, and I'm asking the board to reconsider that law, there is really no incentive for employers to bargain in good faith with unions. Why? Because they can draw it out, refuse to bargain. It goes to the board says, yes, you're unlawfully refusing to bargain. They take it to the circuit says, yes, you unlawfully refuse to bargain. 3 years later, the employer's told, okay, start bargaining. Prospective bargaining order. So during that 3-year period of time, the employer doesn't have to pay any improved wages, benefits that they would have had to based upon good faith negotiations, undermine union support, undermine confidence in the government who certified this union 3 years ago. So that, to me, just does not seem like the way it should work. So what I'm proposing is that, and if you hit employers in their pocketbooks, they somehow change their conduct. And so what I'm asking the board to do is, where employers have unlawfully refused to bargain in good faith, that they have to pay their workers for the lost opportunity of the gains that those workers would have made 3 years before when their union was first certified. And you know, this is not novel. Actually, I wish I could take, you know, full credit for like coming up with this, but you know, the California Ag Board and the Ontario Labor Relations Board, they have, with success, used comparator collective bargaining agreements in the same industry, same classifications, and said, this is what, you know, if there was bargaining in good faith, this is what it would have looked like, and this is what you need to pay. And now, you know, once you've paid your workers accordingly, okay, now let's bargain in good faith and reach a collective bargaining agreement. So anyway, I think I'm going to stop there. I will just say at the very end, I mean, I've been with the agency now 25 years with a short stint during the Trump administration with CWA, which was great. And my goals have been the same as they've always been. It's to educate, protect, and enforce, because our mission is about ensuring that workers feel that they can raise their voice and be heard and improve their work circumstances. And, you know, we all know workers aren't alone. There is strength in numbers. And with the challenges that we have faced and that we continue to face, it's really important that employers are out there, their practices, their structures are critical, as long as they're good ones, are critical to our industrial stability. And I really believe that if workers, and now they are elevating their voices through their union representatives and not, when they elevate their voices and their issues and concerns are addressed, it diminishes workplace conflict, and that is a win for the workers, you know, and their families and their communities, and also the businesses. Everyone gets the opportunity to thrive. So that's a win-win, and that's the way I look at things. And now I am happy to take whatever questions you may have, but thanks for listening. If I sit, can this, is the podium blocking you? Yeah. Okay, I'll stand. It's fine. It's okay. It's all right. It's okay. Okay. Sorry.
Yeah, so
I know I
think,
move around a lot. Apologies.
we have microphones. There you go.
Okay, Ken Esty. Question I have is twofold. One, the Republican attack on the administrative state and the whole major doctrines question that's coming up, does that affect your work? And then the other question is, and I'm vague on the details, but you'll know for sure, is the recent deliberations, I'll put it that way, in the Supreme Court or somewhere trying to take cases out of the jurisdiction of your work?
Yeah, so I'm not going to talk about any sort of active cases at all. I mean, of course, we're always concerned. I mean, as I said, you know, I feel very strongly that, you know, we need to have broad jurisdiction. So, you know, you certainly don't want any entity trying to pull jurisdiction from us. And in terms of your first question, it's not really affecting my work at all.
Oh, hi, sorry. So exciting to hear you speak about, you know, restoring our labor laws to sanity, and, you know, collective bargaining is the, you know, policy of the United States federal labor law. So thank you for protecting that. I heard you say under the statutes, the union can be designated or selected, and there's nothing wrong with voluntary recognition. I'm a 12-year member of Hotel Trades Council. I became a member twice, actually, through voluntary recognition at 2 different hotels. Tons of workers, we don't know exactly how many, I don't think. Maybe you do, I don't know. Become union members through voluntary recognition. There are laws in Tennessee that are recently passed to try and chip away at those rights. There are laws across the country that try to ban things like labor peace agreements to prevent these pathways to voluntary recognition, because as you've discussed, the pathways through the NLRB are so difficult and treacherous for workers. So do you, oftentimes these things end up in the courts. Do you see a path to sort of strengthening these protections for voluntary recognition, since they're so important to increasing union density and collective bargaining?
So certainly, I mean, hopefully the board agrees with me here. I mean, that's the first thing. But secondly, obviously, if there was some legislation along the lines of PRO Act, that would be helpful. But thirdly, in Tennessee or elsewhere where, you know, there may be these state laws, you know, kind of anti-union sort of, you know, they're preempted. And we have gone after any number of states who, you know, kind of get involved or enmeshed in our jurisdiction. And since we are the federal government and we are the only federal agency that actually enforces labor law in this country, we have gone in many, many states and many, many courts to say these laws are preempted under our statute.
Hello, I'm Michael Zweig, and we heard in the earlier session, and you talked a little bit about who's an employee, but there's also the other side is who's the employer, and that especially comes up on franchise relationships, and I wonder if you could speak some about that set of dynamics and the issues involved there.
Sure. So, yeah, I mean, as I said, I think we need to be broadly construing the statute. I do think if I didn't, I should have, but certainly part of that is ensuring that we're broadly defining who is an employer. You know, we are and have been with regard to the franchise model, for example, when I was deputy, we felt that McDonald's, along with its franchisees, but McDonald's was a joint employer of its franchisees. They fought us tooth and nail. I won't go into the gory details of that because there was a settlement agreement that was taken over objections, and this was under the Trump board. I wasn't there, which was an unfortunate result, in my opinion, even over the objections of the ALJ, actually, that heard the case. But yes, I mean, you know, right now, I'll give another example, and it is a live case, so I won't go into the details. Well, I mean, I won't go into many details of it, but you may be aware that along the lines of broadly defining employee, I issued the memo about players at academic institutions and whether or not certain college football players, basketball players at private universities or institutions were under the common law employees performing services for an entity, and that entity having control or the right to control essential working conditions / playing conditions. And in that memo, I said that I believed, you know, obviously you got to look at the facts of each case, and you can't just make these broad pronouncements about, you know, whatever. Like in this, the NCAA is always a joint employer with, you know, all of its universities. But we did find in the Northwestern case where we did have the facts that, in fact, the NCAA was a joint employer with Northwestern. And right now we've got a case where the NCAA, Pac-12, and USC have been alleged to have violated the act in a bunch of different ways with regard to overbroad handbook provisions, as well as misclassifying the college athletes as something other than employees. And we are also looking at the joint employer aspect of that.
Thank you. So I feel really inspired of what's happening on your. I'm Francisca Montaña.
She introduced herself earlier, so that's why.
Okay. It's really inspiring to see like how much thinking you have put into like really giving access to the act for immigrant workers, and we know that you have been trying to do this for a very long time. The board has also done this for a long time. I would like you to like kind of help what is happening right now with deferred action and what the DHS secretary said about local agencies and what they have to do has been like in local agencies feel very scared on how to act in this manner. And I wonder if you have some advice for local agencies. I work for one, so for local agencies, but also for unions and how to approach this question. So there is no so much, people not wanting to utilize these new tools.
Right. Yeah, I mean, I could only speak for our experience, but, and actually, we have like a template, a letter that we actually, obviously change depending upon the employer and the workforce. But, we are going in almost all the time, if we're asked. I mean, we have to be asked. That's for unions, worker centers, or anybody. We're just not going to sua sponte presume that there's a potential status issue, right? But if we are asked, and it doesn't have to be by the workers, it could be by representatives, it could be by agencies, it could be by anybody. If we are asked and we have a charge, we have to have a charge before us, then we will issue, ask DHS to use their prosecutorial discretion along the lines that I was saying. So I'm happy if you were to reach out, we could let you know our practices and processes along those lines. But we don't. I mean, the one thing that we don't do that people should know, I mean, first of all, you have to come and ask us. We have to have a charge on file because that's the labor dispute aspect of it. But we don't identify anybody, like say, it's a broad, this workforce is being, their rights are being violated, right? Either because certain people were fired or, we spell out what's alleged in the charge. Someone was disciplined, someone was fired, but there's a chilling effect on the rest of the workforce. And so therefore, if anyone in that workforce needs deferred action, parole in place, EADs, whatever it is, please use your prosecutorial discretion because they are assisting us. The whole point is they are assisting us in our investigations, in our litigation, in our compliance work. And since they're doing that, they have to be available to us, and so that's how, and we have just as much of a law enforcement obligation as you do. So that's how we've been, but I'm happy to chat more. We've got a team, we have a whole team on just this issue, so I'm sure they can give you some more feedback.
Yes,
Region 29, Joe, intern? Go ahead.
Yes.
Looking for a job in Region 2? Go ahead.
As part of the NLRB Equity Action Plan, there was a new student ambassador program.
Yeah.
And in the spirit of raising awareness, which is clearly an issue,
Yeah.
I'm curious what the response has been across the country in various regions and what type of participation are you seeing in that program?
Yeah, well, I'll tell you, I mean, and Teresa Poor, who is the regional director in Brooklyn in Region 29, really spearheaded that program. She's been unbelievable. And we've gotten, in this area, in the Northeast in particular, it's really taken off. I would say that it's not for lack of wanting to do it across the country. It is the lack of resources, and so some regions have taken it up and are like running with the ball, and others are like, it's on our list, but there's these other priorities that are there as well. For example, I'm pushing, as I was talking about my, the interagency agreements and collaboration. I could certainly do what I need to do on the headquarters level, but the local relationships are what really sustain it, and so that's a priority. So a lot of people are engaged in that sort of collaboration, and so it's crucial that we are doing the outreach and we are reaching young people and getting them to think about how they can help communities, right? But I would say this area, great. perhaps middle, not as great, and at the end, it really is a resource issue at this point. But we're pushing it everywhere, and every regional director understands that it is a priority, but because there's a number of priorities, where it falls on the list is the question.
So we can take two more questions, I think, over here and over there.
Eric Bunk, I just want to say thank you for your work. And in my research, I've seen how a lot of young organizers are really very excited about the work that NLRB has done to make their organizing possible. I guess my question is, it seems that that's also, the organizing that's happening is also allows you to pass rulings that otherwise might not have been possible insofar as there's organizing on the ground that allows you to intervene. My question is, how could that be taken further? Because the common sense among a lot of national labor unions is that the NLRB process basically doesn't work for big corporations that are anti-union. And so I'm wondering, do you think that unions should be engaging more in the NLRB process to win first contracts at corporations like Amazon, Starbucks? And what do you think that potential for reciprocity might look like?
Yes, I do. I actually just spoke recently with a group of unions. It's a resource issue. So what I've said is, make sure that, if you're going to file a charge, and, as I said, in organizing campaigns, unfortunately, as you all know, we see a lot of related unfair labor practice charge allegations related to the organizing drive itself. So, but just make sure you have your witnesses available if you're going to file charges. And, you may not want to keep filing the same charges over and over as soon as, there's an interrogation here and here and here. And then the next day there is, and the next day, and then you're filing 20 charges, which is going to delay things even longer because then we have to investigate all of that. So, you just got to be wise about how you're utilizing the NLRB, I think. But to answer your broader question, yes, absolutely. We are going after whatever bad actors are out there, including the Starbucks, including the Amazon. I mean, we got a settlement agreement with Amazon that gave union access so that they could organize. So, and we, as I said earlier, we got an injunction, a nationwide injunction against Starbucks for its union busting strategy. Now, it lasted, as I said, for like 12 hours, and then the judge, for whatever reason, and I don't know the reason, frankly, pulled it back. But we're still going to fight for it, and we keep going in. And in fact, just the other day, one of the things, if I want to seek injunctive relief, it's the one area where I have to go to the board and say, I'm recommending seeking injunctive relief. Here's why. And then they have to yay or nay it. And in every case that I've brought, the board majority has said, yes, it's appropriate, go in. And just the other day I had a Starbucks one, and we will get a nationwide injunctive order. I'm confident we will. Of course, I'm optimistic by nature, but so I don't think that, and in fact, I mean, the larger, for better or for worse, the organizing that is done with the more high-profile organizations, it gets the word out, right? Because it's the press, that's what people see or read about or what have you. And that's like education in and of itself. It's outreach in and of itself. So I think it's really important that you keep doing that.
Hi, thank you so much. I was curious if you could talk about whether you have anything in mind to lock in some of the memoranda that you've issued. Obviously, we're in a pretty good period, I think, with you, but we have the inevitable, pendulum swing of if we're next under an administration that we don't like as much, what happens to that? So is that just like an inevitable feature of the administrative state, or do you have something in mind in terms of procedurally locking that in?
So, I mean, there's, a couple of things. I mean, the career staff at the agency is phenomenal. And there's a lot of processes that are embedded in and will continue to be embedded in. So, yes, and my memos are guidance, right? And so until the board agrees with me, and should, because, my positions are extremely reasonable, you know, it's not the law, and certainly, but once it becomes the law, I mean, as you know, it's very hard to undo it, at least in you know, a timely basis. So, so that's really where, you know, embedding processes and getting the board to act and actually issue decisions, I think is. But on some of the guidance memos aren't about case precedent or the like the, you know, frankly, on the immigration stuff. I mean, I don't really, you know, requiring that we are treating, you know, this vulnerable population with dignity and respect and making sure they have safe access. I mean, I would hope that that's not controversial. So, I mean, I think there are certain things that are, you know, are embedded in, and even, I will tell you, the whole. Okay. So anyway, I think that with regard to our immigration in particular, with the deconfliction process that we have with ICE, that started when I was deputy. It continued even during the Trump administration. So there's certain things I think that are not really controversial that will stick. Anyway, thank you all very, very much. I appreciate it. Take care.
Both of those are off now. They just have to be pushed to be turned on. And this one